Good morning, everyone joining online, and welcome. I know that you are very hungry for the session because last week, unfortunately, it was a public holiday, Tuesday, so we unfortunately couldn't do a tax update. And I know that was frustrating for everyone. So now we can get back to usual and get on with it. All right, so today's discussion is about the judgment in Ndyamara. I've opened it pronouncing that correctly, nomine officio, and others, I think, versus SARS. The case deals with the VAT consequences of unlawful transactions, right? And to my knowledge, this is the first judgment that is kind of the VAT equivalent of MP Finance. You'll recall in MP Finance, the court said illegal receipts can nevertheless attract fiscal consequences, right? I think it was a pyramid scheme in MP Finance, and the guy said, no, the money that I received is not beneficially received by me because it's illegal. I cannot have a legal right to it. And the court said, no, that you intended to use it as your own, and so we will tax it anyway, right? And so there wasn't something like that for VAT. And I have considered this question for VAT before, and I've always said, well, there's a lacuna in our law because we don't know what the answer is, but now we do. For those of you who don't know me, that's my name. I studied a bit of tax. This training is intended for my staff, for those of you joining online, to interest sake only. Right, let's get into it. So, the facts of the case. PRASA procured 70 dual electric diesel locomotives from a company called Swifambo. So, the liquidators are the ones who brought this application. The taxpayer is Swifambo, right? So, the purchase price was approximately 3.5 billion rand, inclusive of VAT. They delivered 13 of these trains and issued invoices and received payments for them. And they paid SARS VAT on these transactions of about 235 million. However, what had happened is the procurement decision and purchase agreement was later reviewed and set aside by the High Court because of material irregularities and corrupt conduct. All right, so they had this contract to sell 70 trains or to provide 70 trains to PRASA. They delivered a few, they invoiced something and they paid some VAT, but the contract was then subsequently set aside and declared void ab initio. Right. Swifambo was in liquidation. The liquidators sued SARS to recover the VAT, the 235 million rand VAT that was paid. Right. The claim for this money to be paid back to them was framed under Section 26 of the Insolvency Act, which means that they were trying to argue that the VAT was paid to SARS as a disposition not made for value. And the argument was that if the contract was set aside ab initio, then the VAT was never due, and so the payment to SARS was not made for value. That's how they framed their request. Right, I will reserve my comment on that. Right, the taxpayer's argument was that because the contract was set aside retrospectively and treated as void ab initio, the contract never legally existed, which is true. There was accordingly, this is now the taxpayer, accordingly no taxable supply in law. If there's no taxable supply, there can be no VAT. If there's no VAT, then it's a disposition made without value. Alternatively, they said that if they have to account for VAT, then it can only be on the 13 locomotives that they actually delivered, and not the full 235 million, which would have included progress payments, etc., etc. So then they said, okay, fine, if I have to pay VAT, it's only on the 13 that I actually supplied, not on the other ones where I received progress payments. All right. So the argument went. SARS's argument, the VAT liability arose under the VAT Act, not under a private contract alone, right? So the point is they're saying that the VAT obligation doesn't arise under the contract, it arises under the VAT Act, right? Swifambo made taxable supplies, issued invoices and received consideration. Section 9 triggered the time of supply, and the lating setting of the side of the contract doesn't take away the fact that VAT was due, right? Illegality, according to SARS, does not mean a transaction has no fiscal consequences. And if I pause there for a second, it seems a bit odd that you could have a contract that is void ab initio and then still have to account, according to SARS, for the VAT. So before I move on, because I know all of you read the judgment, I'm kidding, that's why we have these training sessions, what is your view on this? I mean, the contract is set aside, it doesn't exist. Should there be VAT?
Yeah.
Everybody says you've been working for me too long, right? Everybody says yes. Who says no? Right? All right. Let's look at what the court said. The court said the definition of supply in the VAT Act is broad, right? And the fact is that Swifambo had trains and they gave it to Prasa, and that is a supply for VAT purposes, right? So a valid enforceable contract is not required for there to be a supply, according to the court's reading of the definition of supply. And the definition of supply, as we know, is exceptionally wide, right? And the court said, well, they carried on an enterprise and they supplied these trains. The fact that they used subcontractors is neither here nor there. And so the court said, well, on that basis, the VAT obviously was due. And if the VAT was due in terms of the VAT Act, then it cannot be a disposition made not for value, right? And so the liquidator's claim was dismissed. And so the point being is that illegal receipts, which this is, or receipts made or supplies made under contract subsequently set aside, does not erase the past VAT consequences, right? That's what the court said here. Now, there's a couple of things, takeaways from this judgment, which the court does not deal with, right? The court deals with this issue of whether VAT was due on the 235 million, whether it was a disposition made, and the court said no. It wasn't a disposition not made for value, it was made for value because the VAT Act imposed the VAT liability, so no, you can't get your claim back. But it raises questions in my mind when I say, okay, fine, if we say that that's the law, let's just consider briefly what the court said years ago in the Respublica judgment. You recall the Respublica judgment. Whenever I issue a VAT opinion, Respublica is the first thing I go to say to my client, where's the contract? You want me to express an opinion on the VAT consequences? I need to see the contract, because in Respublica, the court said the contract is crucial, right, to determining the VAT consequences of a transaction. And so my initial knee-jerk reaction when I saw this, I said, but hang on, isn't this then, this judgment at odds with the principle in Respublica? If we say the contract is so crucial, and now we said the contract doesn't exist because it was set aside right from the start, ab initio, how does that contradict Respublica? And I think the answer is it doesn't necessarily contradict Respublica. I think the point is that, or the more accurate point on Respublica is that the contract is there to characterize the nature of the supply, right? It doesn't determine the validity of the supply. It is to characterize the nature of the supply and the obligations and rights between the parties for the purposes of establishing how the VAT should be accounted for, not whether that should be accounted for. And so I don't think the judgment is necessarily at odds with the judgment in Respublica. I don't know whether this is taken on appeal or not. We'll see. As I said before, this is, in my mind, the first judgment on, or the VAT equivalent of MP Finance. Illegal receipts remain subject to VAT, right? This question, a similar question to this came to me, like I said before, and I said that I think this would be the result, and now there's a judgment that says this is the result. Slightly similar, right? Right, and then the last insight is the question I had in my mind when I looked at this. I said, this is a, you know, when I read a judgment, there was a couple of years ago, there was an application in the tax court to amend an objection, right? And when I read the thing, I went, what is this? It eventually ended up as AXA versus SARS, or SARS versus AXA, and the SCA, and SARS won, and for all the reasons that I said they were going to win, they won. But when you read something like, it seems very odd to use section 26 to try and set VAT aside. The same was an application to amend an objection. What? It immediately sits uncomfortable with me. Why would you go down that road? I mean, I understand why they went here, because they were trying to say that the VAT was not due because it was set aside ab initio. But it did make me think, why are you going down section 26? Why don't you just go down the credit note route? If you know, my logical thing, there's probably a reason for it, right? Remember, if we go credit note route, there has to be restitution, right? The goods have to be returned and the money has to be returned. And so the contract was set aside, and as far as I could tell, when you look at the judgment where the court set aside the contract for the procurement of the trains, it just said it's void ab initio. It didn't order restitution, though I'd imagine that it has to take place. And so my question is, why did they not just go down the credit note route, right? to claim it back and submit an input tax claim. Now, it might be that there wasn't a credit note event, because remember, credit note events, we had a case like this. Remember, we discussed the bank with the, you might have been on leave, but we had that case where the bank issued like rewards and credits against the banking fees, and the question was, is that a credit note event? Because whilst you can issue credit notes for accounting purposes for whatever reason, right? VAT credit notes or credit notes only have VAT consequences if it's a Section 21 event, right? So you can issue a credit note for accounting for, I often get the question, can I issue a credit note for this? Sure. I mean, nothing stops you to issue a credit note. The question is whether the VAT will follow, and it will only follow if it's a Section 21. And so here, the main reason why they might not have gone down that is because there wasn't restitution. There wasn't a return of the stuff, and so therefore the Section 21 event could not have triggered. And that's why they went through this, what seemed like a long way to get the money back, right? That's at least how it reads to me. All right. Takeaways: unlawful transactions doesn't mean there's no VAT consequences. And you know, I've said this before. The 21 thing came to mind almost instantly when I read this. And you often find that when people are entering into a dispute with SARS, you often find, and I don't know, maybe they considered Section 21 and ruled it out, right? But if you are going into a dispute with SARS, sometimes if you don't necessarily have a proper and full understanding of the substantive tax law, you miss arguments that are glaringly obvious, right, to get the problem resolved. It seems to me like going down the 26 route. Of course, I wasn't privy to the conversations, and maybe these guys considered it. But I've seen similar instances where people try this very long-winded way of trying to get something resolved. And I said, but the answer is right in front of you. You don't have to go down this long-winded way of dispositions not made for that. Just do the credit note route, follow the credit note route, if it's possible.